Matt Ludwig from Nationwide, right? Is that
That's
right?
correct. Yep. Yep.
Nationwide is here to talk to us about how to avoid taking on others' liabilities. Matt, you want to take it away?
Absolutely. I'm going to go ahead and take control here and share my
Oh yeah, let
screen.
me stop sharing. There we go. There you are.
Awesome. So hopefully you guys can see my presentation. Can you? Awesome. So what we're going to talk about today is how to avoid taking on others' liabilities. It's a really big issue, not only from an insurance perspective, but also from a legal perspective. So I have two caveats that I need to share before we get started with this presentation. One, I am not a lawyer. So you're going to probably prompt some questions on legal language or, if this protects you or if that protects you. And I'm not going to be the person to ask that question. So right off the bat, I want to make that clear that I can share with you some ways that we can transfer risk, some ways that we can protect your liability. But for specific legal questions, I really recommend going to your legal counsel or the people that you converse with on your contracts. Nor am I an insurance agent. So I can't give coverage advice, but what I can do, and this isn't a real heavy insurance discussion to begin with, this is more about contracts and how we can protect ourselves when doing business with other entities. So that's really the crux of what we're going to talk about today. Start by defining the term negligence. So it gets thrown around a lot, especially in the legal community and also in the insurance community. And basically it's defined as any failure to exercise care that a reasonable person under the same circumstances would take. It's easy to define, a little harder to prove. And that's because there's basic elements that have to be in place for it to be considered a negligent act or negligence. One is we have a duty owed to somebody else. And the example we like to use is car drivers and traffic and things like that. So every driver has the duty to others to operate their vehicle carefully, safely, and with the confines within the law. So that's the duty that we owe others on the road. If we breach that duty, an example would be we operate at unsafe speed, we blow through a traffic control device, we do something that's a violation of the law, that would be a breach of that duty of care. And then the third component is that breach has to be the proximate cause of the damage or the injury to the third person. So if I were to blow a stop sign, cause an accident, somebody sustains damage to their vehicle and or an injury to their self, then that would meet the definition and the criteria of negligence. Again, we're not going to talk so much about negligence, but it is important to define it and put it in terms of what elements need to be present in order for it to be considered negligence. Because should you breach those duties and you're found responsible, you could be found negligent, therefore responsible to pay damages. So again, this is what we're here to talk about. We're here to talk about how do we protect ourselves from those damages that we may be on the hook for, that maybe we could have protected ourselves from in a couple of ways. So we do it through risk transfer. Risk transfer is a mechanism by which we try to shift or convey risk from one person to another. And typically it's between two organizations doing business with one another. And when we do it effectively, it really does place the responsibility for the risk equitably between the two parties, commensurate to their control of the risk. So if I hire a contractor to come in and do work on my building, for example, and I am not part of that repair, I am not offering any assistance, I am not part of that, then my risk or my exposure to that risk should be very minimal because I don't control the risk. It really is 100% the contractor's responsibility to come in. If something happens and my building burns down, 100% of that liability should be put on the contractor doing the work. Now, if I have a part in that and I'm assisting in any way, or maybe I'm providing a scissor lift to a contractor that has to get elevated, and something happens to that scissor lift and it causes somebody to fall or an injury or damage in some way, shape, or form, then I would have some ability to control the risk of that operation. Therefore, I should take some of that on from this risk transfer perspective. But most of the time, we convey risk through contracts, especially when we're talking about a business organization doing business with another organization, two companies, written contract, there's specific language in that contract, which helps us, which protects us from taking on those unwanted liabilities. And I'll talk about some of that here in a minute. I got a couple examples. So I've got 3 examples I want to share with you right now. And then I have a couple examples at the very end that I'll show you kind of where our contracts helped us or hurt us. Example 1 is we have a cooperative that hired a contractor for an expansion project. So that contractor whom we hired a subcontractor to do part of the work, specifically to tear down a portion of an existing building. That one of the subcontractor's employees fell off a roof, sustained serious injuries, was not wearing fall protection at the time. Well, that injured employee sued the contractor as well as the company that hired the contractor, our cooperative, claiming they failed to have a proper safety program and provide proper supervision and just overall provide a safe working environment. So I'm going to go through these 3 examples, and then at the very end, we'll talk about what contract language may have protected us in each of those. So example 2, we have a dairy operation, hired a local mechanic as an independent contractor, so not an employee, to service their truck fleet. A dairy employee, while driving the truck, recently been serviced, was involved in an accident resulting in a fatality to a third party. So as well as serious injuries to our employee dairy driver. So the investigation revealed the accident was due to an improper brake installation by that independent contractor mechanic that we hired. So keep in mind, just keep that in your minds here as we talk about how we could protect ourselves. And example 3, we have a worker in a produce company injured by processing equipment that's missing a guard, so a machine guard. The equipment is owned by a subsidiary, not the parent company for which the employee works. So the injured employee got workers' comp benefits for the bodily injury and lost wages from their employer, but then also made a general liability claim against the subsidiary for which he's not an employee. So if you're familiar with the workers' compensation program, workers' compensation is the single mode of remedy. So where employers get benefits from workers' comp is it doesn't allow the employee to sue them under the general liability. It's the exclusive mode of remedy is the workers' comp, and that's how they're compensated. But since he's not an employee of the subsidiary, he files a general liability claim against them. So how do we protect ourselves in all 3 of these cases? Well, first off, if we had a contract in the example 1 where the general contractor hired a subcontractor, if we had a contract for a liability of loss and some language in there, there's 2 things we want to make sure of we're doing. If we're making a contract between us and another organization, we want in that contract to spell out what minimum levels of insurance we require by the other company. Doesn't matter if we have a contract in place, we have indemnification language in place, we're protected that way. If that company does not have insurance or is underinsured, it won't matter what that contract states, we'll be on the hook for it. So make sure we're spelling out minimum levels of insurance, make sure they have workers' compensation, they have minimum levels of general liability coverage, and then have the proper indemnification and hold harmless language. And I'll give you some examples of what those look like. The second one for the mechanic, if we were able to have a contract stating, again, they have the proper levels of insurance, their level of risk commensurate to their protection of the risk was 100% because they're doing the work, they should hold us harmless in any lawsuit against them or us based on the fatality of that accident. Again, that is part of that contractual language. And then example 3, waivers of subrogation. So waivers of subrogation basically say that if the workers' compensation is paying for this injury, then a waiver of subrogation means the workers' compensation insurance carrier cannot then come back to the general liability carrier and seek recompense for the money spent on the workers' comp. So it's basically we're trying to avoid subrogating that loss, and the single mode of remedy is going to be that workers' compensation insurance. So we're not allowing their insurance company to come back on us and try to recoup funds that they've already spent out in workers' compensation. Again, it's very legalese. It's something that your counsel, your lawyer should be able to read these contracts and make sure that you've got the proper language to protect yourself. So how do we transfer risk? We transfer risk a couple ways. One of the most common ways we transfer risk is through insurance. Insurance is a risk transfer mechanism. But you have to understand also that depending on how much risk you're willing to take on yourself, and the rest would be transferred, the more risk you transfer, the higher the cost of the insurance policy, obviously, right? So you have to kind of do that self-assessment to say, how much risk am I willing to take on myself? And at that point, then I can insure it. The other way we do it, and the most common way we do it when working with two companies, is through the contract. And again, it's most beneficial if we can structure the contract where we're protected the most. We transfer as much risk as possible. But again, the equitable thing to do is to make that language so that your level of control of the risk is commensurate to the amount of risk you are taking on yourself. So here are some of the languages that we'll be specifically looking for in a contract. So additional insured clauses. What this does is it requires one party to add another party as an additional insured on their general liability policies. We get a lot of pushback. We have in the past a lot of pushback from companies to say, why should I name you an additional insured on my insurance policy? Well, it does two things. One, the contract will spell out that you're listed as additional insured on your certificate of insurance. That also ensures that you get access to what levels of insurance they have, so you can verify through that certificate of insurance that they have the minimum levels that your contract calls for. But also, if that policy ever gets canceled, say they don't pay their premiums, as a listed additional insured on their certificate of insurance, you were then part of that communication chain. So you'll be notified if that company ever loses its insurance coverage. Believe me, we see this quite a bit where, we're doing business with company A is doing business with company B. Company B doesn't pay their insurance premiums or loses their insurance policy, but company A has no idea that that occurred. Then a loss happens. The loss happens and company B doesn't have any insurance to cover it. It goes to the company A's insurance. That's just the way that insurance mechanism and risk transfer work. So by being named as an additional insurer on their annual insurance policy, you get insured that you're in that communication loop in case anything happens, so that you can make arrangements to either get a new company to do business with, or have them ensure that they have insurance coverage at the time of business. The next one, which is probably the next two, are probably the biggest ones that we look for, are hold harmless agreements and indemnification agreements. The hold harmless agreement is a clause that you find in several different types of legal documents. And basically what it does is it shifts or attempts to shift the liability for a loss from one party to another. So what they're saying is company A does business with company B. In their contract, company B will hold harmless company A for any losses under company B's control. Again, it's that equitable dissemination of responsibility for the risk. So they're going to hold them harmless, so they can't be named in a suit. Because we live in a very litigious society. This might surprise some people, but we live in a very litigious society. And when a loss occurs, typically everybody under the sun that's involved in one way, shape, or form is named in that lawsuit. So a hold harmless agreement will help us remove ourselves from some of those claims, as well as indemnification agreements. So one party agrees to indemnify or protect another party. I'll give you a great example. An insurance policy itself, inside the insurance policy, has an indemnification agreement. If you have a workers' compensation policy with your insurance carrier and an employee gets hurt and goes and retains a lawyer, your insurance company agrees to protect and indemnify and actually represent you on behalf of your insurance policy. So it's an indemnification agreement. And the fourth is a waiver, that waiver of subrogation, which we talked about earlier, which is just basically a known right, because you can subrogate losses, but if you have a waiver of subrogation, it does protect you from a part of your insurance policy getting hit through subrogation when a loss occurs. So how can I be sure that we're not taking on risk that isn't ours? It's very easy to do. It's not it's a tedious process. So I would suggest not you yourself read every policy or every document, but at the very least have a legal review of the documents that you're asked to sign from a contractual standpoint, because your legal representative will be the best person to make sure that you are protected in the language. Um, you know, we've got some of those really big companies out there, the Walmarts, the Home Depots, the Amazons. And unfortunately, they're such big players that in order to do business with them, you basically have to sign their contract. There is no kind of negotiation of language terms. You sign their contract if you want to do business with them. And this should come as no surprise that that language is heavily protecting them, not necessarily you. But that doesn't happen really in everyday world with companies doing business with other companies. We want that equitable language that make sure that we're both being protected. And some of that time spent at the front end reviewing those and having your legal people review those documents and those contracts for proper language can really save you, literally could save you millions of dollars. If we have a catastrophic loss or a fatality or something that just these cost millions and millions of dollars. So I throw the term contract out a lot. So what is a contract? So anytime for a contract, in order for a contract to have risk transfer in it, everybody needs to understand what they're signing. And they also need to understand the language in what they're signing. So even though it doesn't look like a contract, it may be one. You may go to an event and they may have you sign a kind of a waiver or even a receipt. You could sign a receipt. And sometimes on the back of those receipts, there will be some legal language. So by signing the receipt or signing the statement or a waiver of responsibilities or a waiver of, basically what you're saying is I will indemnify you if I get hurt on your property is what that is. Sometimes they're hidden, sometimes they're kind of snuck in there, and whether they're legally enforceable or not really does come down to the courts on whether the lawyers, who take it to court, how the judge rules. Simple documents like invoices, bills of ladings, maintenance agreements. A lot of maintenance agreements have some language at the bottom or on the back that can constitute a contractual agreement. And some of those may actually put some liability back on you or preclude you from holding them responsible. So how do we make sure that we're not having risk transferred to us? Because again, when we institute a contract, we want to make sure we're protecting our interests, but so is the other company. So again, make that informed decision, have that legal review of those documents. Your lawyer will be able to tell you whether you're being protected or if you're actually taking on responsibility that shouldn't be yours. And then it's up to you to decide how much risk are you willing to take on individually, and then how else will you transfer the rest? So what kind of relationships might be good for this? So anytime you hire like an outside contractor to come in, do work, electrician, a building contractor, mechanics, somebody who has a specialty that we don't do the work ourselves, we hire somebody to come in. Some farms do a lot of labor contracting, and I have an example here towards the end that I'll share with you on the labor contract. Building contractors, people coming in doing work on the building, say they're fixing a damaged building or constructing a new building or demolishing a part of an older building. Visitors, we see this a lot in agritourism operations. So anytime you invite the public onto your property, you have some exposures there that you need to be protected from. Good news is in the state of Ohio, they've passed that limited liability law for agritourism businesses. So if you're in an agritourism business and you have not already gotten the signs, there's a sign that has to be posted in order for you to be protected. The Ohio Farm Bureau has these signs for you. They're out there. You can put them on your property, and that will limit your liability. But not all states have that. Not all states have passed that. But anytime visitors come on, or you have people living on your property, tenants, and then people who just come in to deliver things, truck drivers who come in, deliver hay, come in to deliver supplies. Maybe they're delivering feed if you have a livestock operation. These are all people who you would want to consider transferring risk commensurate to what their level of control is for that risk. So I've got two examples here that I'll end this with, and I'll open up for some questions. So in this picture, this is an orchard operation. They used contract labor. So the employees that are working in this orchard are not their employees. They're hired. It's kind of hard to see. Hopefully you can see my cursor here, but there is a chain going across the entrance to this part of the field. And it's hard to see because it blends in very nicely with the landscaping and the color of the gravel and the stone. Well, we had an employee on a piece of equipment turning into this field, did not see this chain, hit the chain, got ejected, had some very, very serious injuries. Come to find out, the company that he worked for that we contracted with didn't have workers' compensation coverage. This is clearly a work-related injury. It would be the employer's responsibility to pay for that loss through their workers' compensation policy, but they didn't have it. Therefore, the next area of recourse was coming to our client's general liability policy. We lost this case. It was easy to lose because we didn't have any protections in place, right? So we lost this because the language, we didn't ensure that they had minimum levels of insurance, and the language wasn't such that we ensured that we had minimum levels of insurance. Here's another one. So we had a contractor come in to do work on this silo, and everything was good when he went up the ladder. But as you can see down here towards the bottom, we have a missing rung. Well, this missing rung broke as he was descending the ladder. He fell the rest of the way, sustained some serious injuries. But in this case, we had a contract written up between us and the company that we hired to do this work. And we ensured that they had general liability insurance, they had workers' compensation insurance. And this is a workers' compensation loss because it was in the course and scope of their employment. As long as we could show that we had an inspection, the only thing that we could have been on the hook for is if we failed to show care in our workplace in which we were asking this person to do work. So if we didn't have a ladder inspection program, if they could prove that this thing's been busted for years and we did nothing about it, therefore we created an unsafe work environment, and in turn he got hurt because of it, then we might have some skin in the game from a liability standpoint. But we were much better off because we ensured that they had a workers' compensation policy, and that our contract stated that that would be the first course of remedy if one of their employees got hurt. Hopefully that makes sense to everybody. So again, with the caveat that I'm not a lawyer, I will open it up to some questions. If you've got specific questions or if you want to put them in the chat, I'm going to stop sharing so that I can see the chat window in case there's anything up there.
Hi, everybody. I just allowed you to control your microphones, so you can unmute your microphone and ask any questions that you have of Matt or have a conversation.
Okay, Matt. My name is Brenda Hackett, and I'm actually from Kentucky. We have a farm in Greenville, Kentucky.
Mm-hmm.
It's somewhere around 700 acres. My uncle, who was actually over the farm, made all the decisions, everything, recently passed. So now we're having to operate as a group. Okay. We are incorporated, which is helpful. Mm-hmm. But now, what do we do with the land? Where are we going at this point? So who would we need to have on board? Are there lawyers who are just out there? You said you're not a lawyer, you're not an insurance salesman. Are there other people?
Yeah.
I'm in the state of Kentucky now. Okay.
I understand. And we have, so this is a conversation you should have with two people. One would be obviously a legal representative to make sure that you've got everything allocated the way you want to be allocated. And two was to make sure, I would talk to your financial person. It could be your insurance person as well. Nationwide has a program called Land as Your Legacy, and this is what this is for. It's for planning for kind of the next generation, that if something were to happen to the owner, how does that land stay within the family, within the farm, mm-hmm. And how we set that up from a financial planning basis. And there's some legal components to that as well. So the legal avenue is what I would explore first. Mm-hmm. Find an attorney, say, here's what we're looking at. We are incorporated. Here's the land. This is where we are. What would they suggest? Because I assume, Brenda, your plan is to keep the land, right? You want the land to stay
Yes,
within the
yes. And
organization.
what are we going to do
Okay,
with it? You know,
correct,
we have
correct.
family members who want to do this or that. So,
Gotcha. Yep, yep.
uh-huh.
So I was a financial planner and a lawyer would be my first two calls in that case.
Okay. And you said Nationwide offers financial planning
We do.
specifically
Yeah, we
in
have a
this
financial,
area?
yeah, we have a financial services division that looks at, yes, this is what they look at. We have a program called Land as Your Legacy, which may be helpful.
Landish. Okay.
Yep. And you could
Okay.
reach out to any, you could go online and look at Nationwide Financial Services, and we're around, we're nationwide, obviously, not
Okay.
not just in name.
Okay. Now, the information you gave us was general or applied to any
Correct.
state, right?
Correct. Yes,
Okay.
correct.
Okay.
Yeah, it's kind of a 30,000-foot view of kind of how to protect yourself. Each state may have some nuances. That's why I
Mhm.
recommend going to a local attorney.
Okay. All right. Thank you.
Yeah,
You have a question in the chat now, Matt.
do I? That's exciting. Okay. So the questions: for many small and or beginning farmers, accessing professional services can be difficult because of costs. Can you recommend resources or best practices for people to learn about these issues or to locate service providers? I would start with a great resource for the folks that are in Ohio would be the Ohio Farm Bureau. There's a lot of partnerships that the Ohio Farm Bureau has, a lot of kind of affinity partnerships that you can leverage. I did this exact presentation last week for the New York Farm Bureau, and New York Farm Bureau has a kind of a legal referral process where they can refer you to legal counsel for up to 2 hours of a free consultation on issues just like this. I don't know if Ohio has the same kind of affinity partnership, but that's where I would start. I would start there, and then I would start call your insurance agent, because a lot of times, depending on who you're insured with, and your carrier may offer some financial services or have some legal services that you could leverage that would help with the cost, if not be free in some cases. That's a good question.
Hi, Matt. This is
Hello.
Aria. Thank you so much for being here with us this afternoon. We really appreciate it. To follow up with Ms. Hackett's question and your response to Hannah, would it benefit Ms. Hackett to also reach out to the Kentucky Farm Bureau?
Yes, I would. Yes, I think so, because it's hard to know what partnerships they're available to their members. And, if you're not a member, they're going to probably push you to become a member, but there could be some benefits to that membership. Yeah, that's a great call out, Ariel. Thank you.
Thank you.
Fantastic. I'm not hearing too many other questions, nothing in the chat. Hopefully the conference is going well for everybody and they're finding the information useful. Good.
I just posted the link to the Kentucky Farm Bureau website in the chat.
Thank you.
Also, so I had kind of a question, an interesting observation about liability, and you said that if you have a contractor and on the property who doesn't have the proper coverage, then there is liability or potential liability. Are there what are the limits to that? I mean, does it just sort of the full liability then fall to the other group, or is it a lesser liability? Or
so it depends on the venue. So some states, depending on if it's a pure comparative state, contributor, there's states that are called contributory. So if you're 51% found at fault, therefore the full liability goes to you. There's 50-50. So a lot of it depends on the state and the jurisdiction. But here's the important part. The important thing here is, we as farmers like to do business on handshakes, and we've done it for years. So we have an agreement with our neighbor down the street to do kind of swapping of equipment. Maybe we're storing some equipment. Maybe we're borrowing a piece of equipment to transport another piece. And it's worked for us for 30, 40, 50 years. Until something goes wrong, something catastrophic. And if we have a large loss, then it's really not up to the farmers. It's really their insurance companies that are now getting involved. And the insurance companies are going to look to kind of subrogate or mitigate the amount of loss that they're going to incur. So they're going to look for ways to kind of push it off to the other person. And this is where a contract can really help us, because it helps us not drag the claim out. We don't have, and again, it clearly allocates who's responsible for what, commensurate to their risk control abilities. So we do handshake business and something goes wrong, it's really not going to be up to the farm owners who's responsible for what. It's going to be the insurance companies kind of fighting it out on who shouldn't pay. And it's just good business practice to protect ourselves in the formal contracts and have it in writing and have it signed, and just legal people will really kind of help you through that process.
Thank you.
Yeah, Brenda, so my information, April, you're welcome to forward my information to the attendees if you've got follow-up questions. Again, I'm not going to be able to help you with any legal questions, but I might be able to point you in the right direction. Feel free to reach out to me. My email will be hopefully available to everybody.
What is the legacy program that you mentioned?
It's called Land as Your Legacy. It's through our financial services division, and basically it is that estate planning piece for legacy farms to pass down through generations. It's a way to protect the farms and the assets to stay in the family and stay where you want them to go. So it's a financial planning piece.
Is it okay to put your email address in the
Please.
chat?
Please. Yep, that'd be fine. Perfect.
Excuse me, Matt.
Mhm.
Hi, Brenda and April. I know you guys are about to cut out, but I just wanted to know if you have any information about land trust or dealing with community land trust, or if Nationwide might have some ideas about how people in community land trust can.
Yeah, that's not something I've got a lot of experience in and won't be able to help you, but our financial services team would probably be the people to talk to about land trusts and how they kind of fit. I would talk to Nationwide Financial. Sorry, I didn't have a better answer for that.
Oh, no, it's been a whirlwind already, so I appreciate you even thinking of that at all.
So is there a general rule of thumb about how long an arrangement will last with risk shifting would be more important, or another way to think about risk that would be helpful? So obviously, anytime we think about risk, the more we can prevent, the better we'll be. So, prevention of loss is obviously the key. Not always realistic in all cases. That's why risk transfer exists and why it's important. Rule of thumb basically is contracts are typically good for a year because your certificates of insurance, your insurance policies are good for a year. So if you have a written contract program, you're requiring COIs of people you're doing business with, those should be reviewed on an annual basis to make sure they're maintaining their insurance coverage, they're maintaining the minimum levels of insurance coverage that you're asking for, and they still have the policy. So really, annual is really kind of how long the arrangement should be. It may not need adjusting every year, but something to look at, get an updated certificate of insurance every year just to ensure you're protected that way. Oh, you're very welcome.
Hannah, did you want to speak here a little bit with your question and stuff? She has some more posted in there, Matt.
Mm-hmm. Let's see here.
I think Matt answered it.
Yep. Yeah. Okay.
Oh, okay. That was the question you were
answering. That's what I was
Got it,
addressing.
got it.
Yep. I'm able to see the chat now, so I can keep up on it.
I know it's so hard with one screen to see all the things that are to see.
Sometimes, yes. Well, I want to thank everybody for having me on a Saturday afternoon. I hope the conference has been good. I hope the information we provided is helpful. And even though I can't answer the specific questions, hopefully point you in the right direction and give you some areas to maybe look at to help you and your businesses protect yourself.
Thank you, Matt. We really appreciate it. Very informative.